Hi, my name is Gunn and I'm one of the lawyers with Gunn Law Group in Edmonton. You may have heard a lot about how the laws on impaired driving have changed in Canada. Actually, they have changed both provincially here in Alberta and federally across the country. This video is going to outline just some of the ways in which the laws have changed and how those impaired driving laws might affect you or people that you care about. So first, in April of 2018, the law here in Alberta changed. Before that, if you were charged with impaired driving, driving with your blood alcohol level over the legal limit or refusal, you were given an immediate license suspension, and it was indefinite. It stayed in place until your charges were resolved in court. After April 2018, you were given a 3-month license suspension followed by a 1-year suspension. Why the change? Why 2 different suspensions? Because after the 3 months, you could drive with ignition interlock for the other 12 months. That's one of the changes that took place. That was in Alberta. Federally, the law changed on December 18th, 2018, and those were significant changes. First, you may have heard about random breath testing. And this sounds very radical, but actually it's not that new in a way. The officers in the past could always stop you for document checks or sobriety checks. But if they wanted to do a screening device test, that is to ask you to blow into that little handheld device at the roadside to check to see if you have alcohol, they had to have a reasonable suspicion that you had alcohol in your body. Now, if the officer has a screening device test with them, and if they have the ability to see that you were actually just driving, then they can ask you to provide a sample of your breath into the screening device right away without having that suspicion that you have alcohol in your body. The other way that the law changed in December 2018 is in respect to what happens if you don't. Before December 2018, before December 18th, 2018, if you refused, you were looking at a minimum $1,000 fine, a minimum 1-year driving prohibition, and a minimum 3-month wait period before you could apply for ignition interlock. Now, if you refuse, you're looking at a minimum $2,000 fine and a 1-year driving prohibition, but little ray of sunshine, you may not have to wait before you get ignition interlock. These are just some of the many changes that have come into being as a result of the amendments of December 18th, 2018. Contact Gunn Law Group to find out how these changes and others might affect you or people you care about in the future. We'll help you get your license back and your life back on track as soon as possible. Thank you.